How you doing? I like your shirt.
Thank you. You know where you can get one.
Is this,
This is from WCA.
okay, the revised one? Sue edited, and so this afternoon about 4, and so this is their revision.
Okay. Good evening. At this time, we'll call this special city commission meeting to order October the 9th, 2014 at 5:33. Please stand for the invocation, and following that, we have the Pledge of Allegiance.
Shall we pray? Our gracious Heavenly Father, tonight as we stand in this place, we are reminded of the beauty of your creation, the wonder of the fall season that is before us. Lord, we thank you for all the blessings that you've placed into our lives, and we ask, O Lord, for the continued flow of your grace into our community, among the people, and, O Lord, especially in this commission room, that all who come into this room might work together for the benefit of our community, and that your name might be praised in all that we do by that which we do. In Christ's name I pray. Amen.
Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, sir. Roll call. Present.
Present.
Here. Okay, thank you. At this time, we'll take a motion for the approval of the agenda.
I'll make a motion to approve the agenda as is.
Second.
Have a motion and a second, and discussion or questions? Hearing not, all in favor, indicate by saying aye.
Aye.
All opposed, nay. Motion carries. Okay. First business items is discuss the request and direction from the city attorney's office.
Mr. Mayor, we called for this meeting this evening and appreciate you all being here. As you are aware, we've been in a lawsuit with North End as the plaintiff and has sued the city. And the parties have attempted to resolve that litigation over some period of time. And now we're getting close to probably the conclusion of that process. And then also there's another entity, Capital City Bank, that asserts its rights under a developer agreement. And we've been in negotiation with that entity for some period of time. Right about the conclusion of that negotiation process, another entity rose its head, and that's High Springs Hills Properties. And they owned the property that Capital City Bank now owns. There was a foreclosure suit and a deed in lieu of foreclosure that occurred. And of course, Mr. Howe, who's the developer, is developing on that property, is seated here this evening. Mr. Rick Howe and his development corp building houses on that property, is building through Capital City Bank and its ownership of the property. Now, the issue has become whether Capital City owns the rights to that agreement, or does High Springs Hills Properties own that rights to the agreement? And both parties are saying that we're entitled to the monies that are available and contemplated under that agreement. But what Courtney's done is prepared a litigation packet for you, and hopefully you all have that, which has the old agreements that were entered into and a number of documents associated with this litigation, the back and forth, some of the complaints that have been filed, and then some of the related documents as well, because we wanted you all to know what's going on have a flavor and a feel for where we're at and where perhaps we're going. So that's the intent of this evening is mostly informational for you all to get up to speed. And if you have questions of the city attorney's office, we're more than willing and we'll answer the questions to the best of our ability. Of course, this is a public format. It's not set up as a closed door meeting. You have the ability to do that when a case is in litigation. If a case is contemplated for litigation, you cannot close the doors on it. And so when we set this meeting up, it was anticipated that litigation may come from Capital City Bank, and now it has. They've actually filed the proceeding, and they're going to serve the paperwork to actually get us involved formally in the case on our mayor. That's the way you serve process on a city. And so that is in the works, which means that the negotiation process may be coming to a close. But Mr. Mayor, as you know, in litigation, before you get to final hearing, and at least in our circuit, you have to go through another process, which is called mediation. So there will be a formal sit-down that High Springs Hills Properties probably will be brought into this litigation. Capital City Bank will be in the litigation, is in the litigation. City of High Springs will be in the litigation, and then North End will obviously is in the litigation. So at some stage, if the parties are not able to settle their differences between the lawyers and between the parties, then a trained mediator will come to the mediation and try to work it out between the parties. And if that can't happen, ultimately it goes to a judge, and the judge will make a ruling, and whoever is aggrieved of the ruling may take it up on appeal or not. That's their choice, and that's how the process works. So that's where we're at right now, and just kind of giving you a real quick summary of where we've been. This emanates out of December 8, 2005 agreement between High Springs Hills, City of High Springs, which was referred to as the city in the agreement, High Springs Hills Properties, Inc., a Florida corporation, hereinafter called High Springs Hills in the agreement, North End Homeland, LLC, a Florida limited liability company, also known as North End in the agreement. And the gist of it is that North End is the owner of 90 acres, more or less, and the site's been approved for a subdivision of 114 lots. North End still owns the property, and they're still a party to the agreement, and they're proceeding on with the development of the
North
property.
End, Scott, North End owns Weston Oaks.
Right.
Yes.
Right.
Do they have any part of Oak Ridge?
No, they do not. To my knowledge, they do not. And then, and the agreement says North End owns Weston, is going to construct Weston Oaks subdivision with 114 lots. High Springs Hills has a contract to purchase the Sullivan property and is currently zoned commercial. They're going to rezone it for a home subdivisions with approximately 220 lots, and they'll go forward with the process. Now, the parties have a proposal from a private contractor to install a water and sewer line with plans provided by the city easterly to County Road 202 with approximate cost of $592,700, which the parties believe may increase. And then the other extension is going to range from $300,000 to $400,000. That's what was contemplated at the time of the agreement. Now, the pertinent part of the agreement is Section 8, which basically says that the city will credit against each developer's costs and expenses. So the developers are going to pay for the extension of the line. And if we look at paragraph 4 on page 2, it says North End will pay up to $592,700 for the construction of the line. And then High Springs Hills will pay up to $457,300 for the construction of the line. And now the developers will be then reimbursed for the costs of the sewer and water line extensions And the city, and this is that paragraph 8 I was just referring to earlier, city will credit against each developer's cost and expenses for the water and sewer extension $2,960 per residential connection. With regard to connections to water extension by parties other than the developers, the city shall pay the developers prorated by the investment of the developers the sum of $2,960 per residential equivalent unit for each residential unit to that portion of the water and wastewater extension provided by the developers. And the $2,960 shall be a portion $970 for water and $1,990 for wastewater. The agreement shall be extended for a period of 10 years, beginning on the date of the execution by the parties to the agreement. And as I said earlier, that agreement was entered into on December 8, 2005. And that's an important point because one would anticipate then, by virtue of the terms of the agreement, that this agreement ends December 8th of 2015. North End, as was mentioned, is Weston Oaks. There was an agreement to modify the agreement, and the city signed off on it, and both parties signed off on the agreement. And then the parties amended the agreement, and whereby they changed the numbers that they had into the deal, whereas North End is total investment in the project for the sewer and water line was $256,681.45, and High Springs Hills increased their investment to $754,430.10. The agreement also says that High Springs Hills will receive all of the 2960 credits for the first 50 equivalent residential connections not located in Weston Oaks or Oak Ridge. So that was the principal amendment to that agreement. And again, this amendment is signed off on by all parties to the original agreement.
Scott,
Yes.
not located in Weston Oaks or Oak Ridge. What other?
Along the line that goes along Railroad Avenue, we've had about 9 connections
So that's where
in the 10 years.
what they're referring to is
That's correct.
that, not another subdivision next to Impact Church or something.
That's right. That's my understanding of what the parties did at that time. Now, I think your manager's experience and my experience is that if I'm extending a line to service my development, and this is where it kind of gets interesting perspective-wise. If I have a development and I need sewer and water, then traditionally my experience, and I think your manager's experience, is the developer pays for that. That's how it works traditionally. This agreement's a little different than that because it says that if you connect in the development, you're getting reimbursed for connection fees of $2,960 per connection. That's a little different than what he's seen in the past in my discussions with him, and it's different than what I've seen in the past. What I see in my experience is that when folks connect to an extended line like that outside the development, that's where the reimbursement comes in. I've experienced that where somebody along the way, not in the development, attaches to that line, then they should pay their fair share because they're making use of what that developer is then paid off on. But that's not how this agreement is structured, and that's not how it works. So I think we have to live with the agreement that was made. That's the contract, and that's the deal that was made way back when, and that's just the way it is. Now, the expansion of the sewer line begins in February of 06, April 21. There's the letter from Gary Grunder to our city manager Drum at the time, clarifying that High Springs Hills and North End's understanding of the developer agreement, which really not altered from the amended agreement. December 6th of 06, High Springs Hills and the bank execute a mortgage agreement, a construction loan agreement, and that's important because of developments that happened after that period of time. December 8th of '06, High Springs Hills and North End execute the First Amendment to the developers agreement. We've talked about that. And then, of course, the bottom falls out of the market in about '08, early '08, and now we've got no construction going on. The cities and all cities and local governments are in a free fall because property values are going down, so our ad valorem income is going down, and revenues for a city and expenses don't necessarily match. Your expenses are staying the same, but your revenues are going way down. Well, the same with the construction industry, and everybody's trying to hang on their hat for the next several years because we're in the Great Recession. And the developers in this instance are no different than that, and their expectations are not met. And in February of '08, the city issues a moratorium, a 2-year moratorium that lasts until August of '10 on impact fees, and which means that you're not collecting any money for water and sewer impact fees. And of course, at that time, rightly or wrongly, the city is also not then reimbursing the developer for the minor connections that are happening at this time. And so we're developing a backlog under this agreement. Let me go back for a second. And interestingly, the parties do not execute a memorandum of understanding or an amendment to the agreement at this time that says, hey, while the moratorium is in effect, we're not going to reimburse you for these connections. So the three parties to the agreement do not do that at this time.
Was it about that time, and I'm going by what I've been reading, about that time, weren't they both becoming insolvent and dealing with the banks?
Yes.
Or one?
I don't know about North End,
both.
but
one
High
was.
Springs Hills Properties certainly was having major financial difficulties, is what it appears from the documents and the records. They're not able to satisfy or meet the obligations for the construction loan that they've got out there. And so, as you note, about that time, September 30th, 2010, High Springs Hills executes a warranty deed to the bank in lieu of foreclosure. So, and there's an agreement for that to happen. And now, interestingly, at that time, the bank probably, we believe, and this is speculation a bit on my part, but I'm not sure that the bank is even aware that there's a underlying developer agreement with the city, because there is a letter that comes out in September of 2012 where the bank sends a letter to our then city manager, Jerry Langman, and asserts its rights to the developer agreement, stating in the letter, since the execution and recording of the above referenced instruments, the bank has learned of a developer's agreement dated December 8, 2005. So now the bank in 2012 is coming forward and saying, hey, we know now that there is a developer's agreement, and we're asserting our rights under that development. We're standing in the shoes of High Springs Hills Properties, and we intend to assert our rights under that agreement. And that continues to be the case, and that's the focal point of the lawsuit that Capital City Bank has brought against the city. They're saying we're foreclosing on that property. We took a deed in lieu of foreclosure, and although the assignment is not specific as to these developer agreements, we believe under the criteria of the law that all of High Springs Hills Properties were transferred to us as a result of this foreclosure process, and we are, the bank, entitled to the reimbursement credits per the developer agreement. So we operated on that basis for some period of time. There's a lot of back and forth between the bank's lawyers and city attorney's office operating on that principle, and High Springs Hills Properties was nowhere to be heard or found until just very recently. An attorney out of Miami by the name of David Friedman came to the table and sent us a letter and said, wait a minute, no money should change hands at all in this deal. You shouldn't give any money or rights to North End, shouldn't give any rights or money to Capital City Bank. You're doing so at your own peril, because if you do give any money out, you're violating our rights under the agreement, which were never assigned, and we're asserting those. We're on notice right now that you're asserting those rights. So we were going back and forth, and in the midst of all of this, and as the development community is before you, and you're trying to kickstart or jumpstart development in High Springs, and work through this, you all and our city manager, if you'll recollect, performed a study, and Midtower helped us with that study, and we looked at the impact fees compared to where we were in that time frame of early 2014 or 2013, and amended our impact fees and lowered those fees significantly. And in July of 2013, the city passed an ordinance where water and sewer impact fees were reduced to $2,657. September of 2013, North End filed its action against the city, and one of the issues that cropped up in that litigation, at least in the negotiations, is, well, if the city is not going to do the final phases, at least in the near future, for the sewer plant, what is our existing capacity, and how much capacity do we have without those additional phases to the sewer plant? So Midtower did that, and they believe that based upon, and again, this is kind of educated guesswork on their part, and their professional opinion is that we have capacity that is outwards of about 2019 as your plant sits right now. Your manager, when he came on board, he's upped the efficiency of the plant. He's given us more capacity by doing that, working with Midtower. So they're doing better with what we have, and maybe there's more efficiencies that can be had. And so maybe the capacity goes beyond 2019, perhaps. On the other hand, the argument could be made that if development picks up and we have more people connecting to the line, and the numbers that we're projecting as far as building out these developments and other developments increase, then your capacity or your time frame for your existing sewer plant will decrease. Now, what happens in that event is that DEP is constantly monitoring your sewer plant and your existing capacity. So when you get to certain limits on your capacity, you have to do certain things. You have to have a plan in place when you hit certain percentages to expand your sewer plant. So although the concern is there that we may run out of capacity, we're going to have to do something about it, and it's our obligation to do something about it when that time comes. And when we start hitting those points, your manager is going to be before you and say, hey, we're going to have to do a phase 3, or we're going to have to do a phase 4, and that's coming, and we'll issue the bonds or get the financing in place and extend capacity. So capacity is an important issue in these negotiations, and it's a big issue to the developers because they want to build homes, and they want to make sure that as they get those homes built, they're not waiting on us to get our sewer plant expanded. So it's a big deal for them. It's, of course, a big deal for us as well. So that's the nature of the history of where we're at and where we've come from now. August 29th, 2014, we received a letter from High Springs Hills asserting that the bank is interfering with their contractual rights. High Springs Hills property has not filed suit, and Courtney has asked Mr. Friedman repeatedly, that represents High Springs Hills, what is it that you're looking for? Tell us. We have a meeting tonight, and at least we would like to come to the city and tell the commissioners in the city what it is that you're asking on behalf of your client. It's only fair that you tell us that. And I think that was the memo or the email, Courtney, that we received this afternoon.
If we have a copy, Angela made a copy
Mhm.
for them up there.
So this is hot off the press, so to speak. Came in at 4:42 this afternoon.
So this is Tuesday.
Okay, Tuesday. And it says that, why don't you summarize it, Courtney?
This is a starting that the city owes High Springs Hills $112,480. They're saying that the outside connection, outside of Oak Ridge, they're entitled to $26,640. So they understand that this is at issue, obviously, with Capital City Bank. So they're requesting $26,000 now, and that a judge decide who has rights under the developer agreement to figure out the rest.
No,
They
they,
have also asked for an extension of the developer agreement, not in terms of capacity, but in terms of reimbursement for future connections that would happen in that development. But they have not given us a timeframe they would like to see that happen. And we have contacted them again, as late as today, and we need to know what that timeframe is they're asking for. We have not heard back. So they are seeking an extension of time.
And I think, for one thing, I talked to the attorneys that were involved in this agreement to begin with. And understand that when the developers came to the city and they wanted to develop their land in quarter-acre lots, because without the sewer, they would have to develop in an acre lots. The city realized that there would be a great expense to it, and to offset the expense, they said we would give you a credit. Nowhere was the intent to pay for the entire sewer line, which started at 202 and ran down to Western Oaks. It was that they had a chance of getting most of their money back if they built all the houses. Now with Western Oaks, we have another wrinkle, because although they said they were going to build 210 homes, they only planted it for a small amount. And most of the land stays unplatted. If they were to come in today and bring us a plan and go through all the process, it'd be a year or more before we would get that approved. So basically, Western Oaks, I'm sorry, not Western Oaks, but Oak Ridge is what it is. There is no other plat. We have nothing. We don't have anything on file. There's nothing at the tax appraisers. And so, and we have that problem of who has standing, who actually owns that agreement. That's a big thing. What the developers, and I've been one of those that has steadfastly said, I don't want to see an extension on this contract. My idea is, if we give them a contract, what are we getting in return? Is it they're not going to go to court? That's not a good reason. So personally, I think we're going to get ready to go to court here pretty soon. Today, these aren't the only agreements we have. Today, the individual that owns the industrial park, we did an agreement with him, and he came in demanding $54,000. See, I think what the developers think is, whatever monies they didn't collect on this, they were going to get a payday at the end. And nowhere in those contracts and those agreements does it say that. It says, you have a chance, we will reimburse you. And I know nobody foresaw the downturn of the economy. Now, in there, of course, they did for 10 years say that we would give them capacity. Okay, that leads us to a few years ago, they all of a sudden came to the realization they had given all the capacity away in the sewer with these two subdivisions. And that's where the $5 million bond that they were trying to float came about. There was a realization that we had to increase the capacity of our sewer because we had all these other subdivisions around that we had to serve, and if we've given it all away, then we had to expand the plant.
The other thing,
Thank God, though, that there was a downturn. And so the downturn didn't allow them to build all their houses. And therefore, we were able to hold on to some of the capacity for the other people. Frankly, to give them more years on the development agreement, I don't know what we get for it. I have told the finance director and myself, we are sitting down and we were going line by line, and we will hold ourselves to the letter of that agreement so that the developers will get what they want. Of course, what makes me mad is that some people talked you into doing a moratorium and then they're sticking it to you. But that's the way it is. You be very careful about what developers tell you because they have a vested interest. That it is what it is, but we are going to do on our part in the city to do what those development agreements are. And I'm sure that we are not going to make the developers what they want. And I know what they want.
the other point that I would make is that your city finance department and your city attorney's office has worked really hard. Sandra, of course, started this project with Hubie some time ago, and she's out with baby now, and Hubie's in greener pastures as well. But it's been followed up with the current work, both through the finance and city attorney's office, to figure out what is the right amount of money, and the numbers that Mr. Friedman referenced in his email, his initial email and his current email, we believe are way off. And what he doesn't compute is that some of the people that he believes, or residences or commercial projects that he believes have connected to the system, really have not connected, number one, so that creates a problem with his number. And then number two, I think he fails to understand or realize that there were reimbursements going on before the moratorium period. So there is money that has flowed from the city back to the developer, or conversely, there is less impact fee money that has been received by the city, considering the credit that they would get of the $2,960 per home or residential connection. And he doesn't compute that into his numbers. But the number is, I don't know that we have a finite number just yet as to what that is, but it's going to be pretty close.
Yes, she's gone through it.
Okay. Why don't we do both by subdivision? To the best of our understanding right now, this is the number.
Without the moratorium, well, before that, we had 27 homes in the subdivision. We had 18 that were done during the moratorium. And then we have 10 that were done outside. Of that 50, up to 50 that they get credit for, there's been 10. So 27 to 10 comes to $109,520, and we've paid them $36,938. So we have a balance of $72,582.
She's referring to Oak Ridge.
Yeah.
Mm-hmm.
What was that, 72,582?
582.
But
And the question, of course, is, not to interrupt, but the question is, were we supposed to pay any money during the moratorium period? That's one of the legal questions that may need to be sorted out in this litigation, and that's albeit there was nothing in writing by the parties at that time, and the contract, to put you in the best position for that argument, it would have been helpful for us to have an agreement entered into at that time by the parties that says, all right, if the city's going to do a moratorium, then conversely, we ain't paying anything on these credits. Everybody sign off on it, then the issue's dead. But that issue's alive now because of the fact that fact did not happen.
I interrupted on, you were probably about to give us the number on North End, Weston Oaks.
They have 12 that were done and fees collected, and they had 2 that were done on the moratorium during that. So for the 12, it was $35,520. We paid them 2 checks, one for $5,920 and one for $23,680. So we only owe them $5,920. That's not counting the more 2 on the moratorium.
The other philosophical thing that I'd point out is that we, the city of High Springs, want connections. We want development. We want developers that build nice houses, which they do in these developments at an affordable cost. And obviously, these homes are in the price point that people can afford right now. So they're building the homes and they're connecting and they're doing that part of it. So I think there's also a philosophical point that we want people to use our sewer system and make efficiencies to the sewer system. And secondly, we want development to occur in High Springs. So it's not been philosophically in our interest to battle or go to war with these folks, as long as I think, like your city manager said, all right, what does the city get in return for amending the agreement or extending the agreement? And all the developers, except really High Springs Hills Properties, because they're not building homes and they have no right to build homes. Capital City has the right to build homes in their development now. And so they're not so much concerned about extending the capacity or guaranteeing the extension of capacity. They're concerned about extending the agreement for reimbursement rates. And as your manager just said, there's a drop dead date on this agreement of December of 2015 that the agreement ends. So that's a line of demarcation that the parties all entered into as well. And of course, Capital City, the big issue for them, and as expressed by their attorney, and I think he's right, is that capacity for the future is really their big issue. And what they had requested in the settlement negotiations was an 8-year extension of capacity, no money, no reimbursements. We don't care about the money. And we said, okay, we're talking, the city is getting something for that, and we're giving something for that, but there's a couple of things that are of importance in there. First of all, we need to talk about what happens if we get into a delay, and a delay period of time, then there's a cessation of the agreement maybe, and it's extended for some period of time. And in the event that High Springs Hills Properties is successful with their lawsuit, then we want an indemnification clause, because it's not a good deal for us to extend the agreement and guarantee capacity for another 8 years. And on one hand, and on the other hand, it is possible that High Springs Hills Properties could come in and say, look, that right was never assigned. We have the right to that. Now we're paying out money, and the basis of our bargain is not there. So that's not fair to us. So negotiations essentially broke down with Capital City, and now that's the focal point in the lawsuit. Now the lawsuit, both from North End and Capital City, is we think the agreement doesn't end in 2015. We think it goes on in perpetuity until such time as we get our money back. That's basically what the lawsuit is asking.
Clarify
And-
for me, Capital City is now the owner of
Oak Ridge.
That's right.
Oak
That
Ridge.
is correct.
No, that's not correct. Wait, excuse me, Mayor, but we own phase one lot.
Come to the mic and
I don't want to interrupt.
No, that's fine,
I'm
Rick.
hearing this, and I just want to make sure I understand.
Yeah.
I own
Give
the
your name
lots
for-
at
give your
Rick
name for-
Howell Development. I own the lots in phase one. I took over the subdivision in 2011 because it had been foreclosed on or taken back in lieu of foreclosure. I had numerous meetings with the mayor before the mayor before the mayor before you and all the mayors ever since, and 3 levels of attorneys and everything else, trying to resolve this in some favorable way to the benefits to the citizens of High Springs. I've never stood before this board ever making any demands of anything. Anything coming out of Tallahassee from Capital City is my directions. I ask them, let's resolve this, let's move forward, and I feel like we're not getting any help here. I'm hearing the developers ask for a moratorium in 2008. I didn't take this over until 2011. When I came in and met with the Mayor Travis, he sat in a meeting with Tom DePeters, with Christian Pelosi, who was your planning director, with Jenny Parnham, which was within the city manager, and a whole host of other staff, and they told me, you have a developer's agreement with me, with us, and you have these rights. And I said, but you have a moratorium that you've had in place for 2 years. Why would I come and ask for a check from you when you're not asking for a check from me? So let's just shake hands and be gentlemen about it. And the reason why I didn't come before you until 2012 is because I told Capital City, because I had them by the shoestrings with their agreement with me, do not do anything. It was only when we ran into this loggerhead where I felt like we weren't getting anywhere that I said, you guys need to make demands. We're here to build those houses out and finish a nice subdivision, bring you a lot of new citizens to High Springs. We need time to finish phase 2. Okay? Alachua County just gave a 10-year extension to a 999 lot subdivision called Oakmont, which was approved 10 years ago, and because of the recession, it went nowhere, and they didn't make any adjustments to it. They just gave them another fresh 10 years. You got 10 years to finish it out because they need that to be built. And you guys need me to build this. We need some cooperation here. I think that we're losing some opportunity to resolve this in a favorable way. And I'm just getting the developer. I've never stood before this board ever in asking for a moratorium on me. I've never asked for a moratorium on impact fees, not once. So I just want people to understand. I think the commission in 2008 and 2009 thought, like all of Florida, there was a lot of cities and counties that were dropping impact fees, trying to stimulate activity. And I think that's where it came from. It was a noble cause, but it was flawed. And I think that you're back on track to do the right thing. And I think the new manager did the right thing in doing the analysis. I applaud him for that. When we came in here, agreed with it. But there's a lot of stuff that's going on for almost 10 years that a lot of us in this room didn't create. And I'm just here to say, I'm trying to be the guy to solve the problem, not create more problems.
Well,
Sorry,
Mr. Mayor, not at all. And Mr. Howe brings a pretty darn good point. You know, I always like to be negotiating with the guy that's got his ox stuck in the ditch. You know, if you're up on the road and he's got his ox in it, and maybe we've been negotiating with the wrong party. I don't know. The only thing I can do, and I can't negotiate directly with a client. I've got to go through a lawyer when they're represented by counsel. So I don't know. And philosophically, you know, my door is always open. I think your manager's doors is always open. And if we're negotiating with a person that's got his ox stuck, but not negotiating with that guy and negotiating with somebody, maybe we've been flawed in the process so far in the negotiation part of it. I think what Mr. House said is correct. Everybody has something to gain, and everybody has a boatload to lose by letting this thing go to a judge. This is a case in both North End and in High Springs Hills that ought to be settled. But we got to get all the parties to the table to do that. And we said that. We said, let's get a mediator. You all do a pre-suit mediation, and let's sit down and talk to everybody. Get everybody in the same room. And by golly, we darn sure ought to have Ms. Howe out there, in my view. And we were turned down with that. So I don't know.
name's Joe Caprio, president of High Springs Hills Property. That's Lee Holloway, he's the vice president. We were the ones that were a part of that original agreement. And back then, the philosophy of this town was a whole lot different than the thought of some people running the town today. Whether we put up our money of $750,000 to bring your city water and sewer down 441. And that was the way the city manager back then wanted it. That was the way the mayor wanted it. And we were helpful enough to put up the money. The concept was to give us a chance to regain this money back. And that was an agreement that was full-fledged. When we lost the property in the deed of lieu of foreclosure, by no means did we give it back to Capital City. We knew exactly what we gave back. And what we gave back was the property. The water line was a whole different entity. I didn't give my shirt that day that I went to the bank and signed over the lots. I only gave them the lots. I didn't give them the water and sewer line. So Capital City really has no bearing on that money. We have claimed that money. I've been to your office, sir, and I've spoke to you. You don't know it. You didn't mention that we have been out of it. I spoke to your Mrs. Leyland that was running the commission back then and asking for the money. They were broke. I spoke to the two law firms prior to you being the law firm asking for the money, and it was constantly, we don't have the money. We're asking for an analysis on how many lots were, and we will get back to you, Mr. Caprio. We will get back to you. We sat patient. We were broken ourselves. So we sat patient waiting for this whole thing to happen. Last year, I was in your office asking for the money back, and, you know, we made a claim for the money. Since then, we let it go dormant one more year waiting for you guys to get on your feet saying that you had no money to pay us. And at the timing of it all, we came out and found out that there was some kind of agreement with Capital City to give our money to them. It's not theirs. We will take a position to let you know to go claim our money.
Right.
We earned it hard, and it's not the bank's. So we're willing to make an agreement, but it won't be with, you know, that in mind of losing a portion of our money. So if anyone wants to know where our heads are at in the end result, we'll fast forward you and make it easier. We want to work this out, and we want to settle it. Our thoughts of why an extension is imminent or only fair. There's a crisis for developers and cities and everybody building through this whole country and whole world. And I could show you 2,000 examples through this state where government people gave extensions on permits, gave extensions and moratoriums were going, and everything became dormant. And for the time of dormancy, when the developer comes back to ask for more time, they understand the reason why they have to give extensions. And they're granted all over the place. So the example, if it were to go to court to ask for an extension, I think is a fair and honest example. It's not trying to take advantage of the city. And if I can imagine when you use the phrase of, what do you get? Sir, you have a water line going 3.5 miles down your major city, and you can offer developers the right to tap into it forever and ever, and you send out a water bill and a sewage bill every month to those people who tap into it. And if it wasn't for our $750,000 that put it up, you would not have that. So I think you do end up with something when you look at the big picture. So what we're looking to do is just settle our business with this situation and move on and let your city grow. And we always had high hopes for it to grow. That's why we came here. I appreciate your time.
Okay.
And thanks for.
So now, Capital City owns High Springs Hills property.
They own Oak Ridge.
They own Oak Ridge with. He said he owned.
According, go ahead.
No, he says he owns the agreement. That the agreement, when the bank took over the land, never went with the land. It was a separate entity. So that's where we're in a quandary, is that we have two entities claiming the same agreement. They have to come to terms themselves and then come back to us. We have the money in the impact fees, we just don't know who to pay.
Mhm.
And we agree that we owe somebody, but we just can't hand over the money to somebody we're not sure is entitled to it.
So our confusion is, do we pay High Spring Hills Property Inc., or do we pay Capital City?
And there
We
is a
don't know.
procedure for that. If you're in that kind of quandary and you believe that you do owe the money, and there's two parties that are contesting who gets the money, then you put that money into the registry of the court, or you put it into some sort of an escrow account, and it sits there, and the judge says, well, you're the one that is the one that wins the money, and you're the one that loses the money, or gets apportioned, or whatever the judge does. So there is a process for us to do that. And if the situation is such that High Springs Hills Properties and Mr. Howe through the bank says we're entitled to that, they could have the biggest fight they want to have. And that's really not our fight.
Mhm.
That's their fight between them, provided that we can agree as to what the number is that's going into the registry of the court. That's it. Commissioner Barnes has been,
Scott, are we in litigation now?
yes, we are.
So we could call for a closed meeting.
That's right.
It'd be my suggestions, Commissioners, to call for that closed meeting to discuss that, to discuss this in a closed meeting, where you go now that we're in litigation. That would be my first suggestion. If you need a motion for that,
What I would suggest, let's do that at our regularly scheduled
Okay.
meeting this evening, and I think it's a very valid point, because at the time we scheduled this, we weren't in litigation. Now we are, and by the time we get to that special meeting, he'll have been
so
served, and we
we'll
can
deal
do
with
our
that
thing.
at the next meeting.
That's right.
I want to clarify something that so in my mind, this may help you, Mayor. Oak Ridge was Oak Ridge, owned by High Springs Hills
Yes.
when it started.
That's right.
Then it went to Capital City. Capital City took it over.
Right.
Took it over, and
And gave
in
it
that,
that house.
in that agreement, which he says they gave them the land and not the pipes, in that agreement, number 13 says, to the bank, all owners' rights. Title, and item number 13 in that agreement from 2010. Then High Springs Hills, that development went to Howe. Howe was not part of the original agreement, though. But on the plats, you own some of the lots in Capital City still own some of the lots, according to the plat.
Being in real estate.
Come to the mic.
2011, I was not looking at this project. Capital City came to me and says, we have a project we just took back in lieu of foreclosure. And that's the agreement you read, Commissioner Barnes.
Okay.
And you are correct in what you stated in all of the rights that went with it. And Capital City is affirmed in my contract with them that they have that agreement. What happened is we were in a period of time where we were trying in 2011. It's easy in 2014 to say recovery's on. Easy in 2014 to say gas is cheaper, recovery's on, elections behind us, we're going forward. 2011 wasn't that way. In January 2011, we took over an abandoned subdivision that had a few disgruntled owners in there, and we had to get this thing going. And we came with hat in hand saying, we need to be a player in this and make this happen. What I think is being lost in this is that, whether or not the city attorney's correct, it's just be between myself and Capital City fighting the developer or their former borrower that didn't pay them. And I think their point is they loaned that money to put that extension out there and buy that land, and that's probably their position, and I think valid in that regard.
We closed on that.
Wait till you get
But the reality is that you had a situation where there wasn't a lot of construction going on. And the moratorium wasn't gonna motivate. $2,900 wasn't gonna make someone build a house when it was couldn't sell a house for a profit. We had to get this thing going, and I think we came to staff with the intent of, you know, what would worry to us was not money, it was the timeline to get it turned around and to get phase 2 built. What I did with Capital City was I bought a batch of lots and I have options, and the options have been exercised at periods throughout this process, including the option for phase 2, which will take place next year. The good news for you is the date of the agreement is probably not as critical to us, is because we fully intend to bring back before you next year the design plan for phase 2.
Right.
Because we're game's on, you know, I mean, and that's a good thing, because and we can get this going, and we can hopefully, because we only have like 30 lots left in phase 1, and at the pace we're going, what we see happening, we need phase 2 to be coming out of the ground by December probably. So I don't even know if that's an issue, you know, in the end. But I know in this day and age, in this business I've been in for the last several years, nothing's a guarantee. You know, we could have one bomb go off somewhere, and all of a sudden what looked like a normal start in March of 2015 becomes, you know, Mr. Booth, I need another year. I would be foolish to start building these roads today. We need time. And I told that to Mayor Travis. I told that to Dean Davis. I told that to Sue Weller when she was mayor. I told that to Ray Ivey. I told that to Tom DePeters. I mean, I feel like I've come to meetings told that this was going to be discussed on numerous occasions at the end of the meeting, and sat in the back quietly only to have the meeting adjourn and realize we didn't talk about anything. And I mean, I love you guys and want to come out and hang out with you, but I got a family too. I'm saying, I think that Commissioner Barnes is onto something. You need to maybe get back together, and then I think you need to decide who you want to negotiate with, okay? Because I think I have Capital City's ear, and I think they have the hammer. And I think that I'm telling you, I live here. I was born here. I'll probably get buried somewhere around here. Okay, good Lord be willing. So maybe city manager is correct. I mean, the city attorney is correct. You need to decide who do we need to be talking to. So I'm anxious to talk.
Okay, so we're getting close to time for the next commissioner meeting here. So you said we have to make this a motion at the next city meeting,
Right,
for to have a closed
at a regular
session?
meeting.
Yeah.
Right, to schedule a closed session, and then we'll get that done.
Okay, so I think that's where we are right now, to do that. And Commissioner Barnes?
I understand time's short, Mayor, but I needed to finish these thoughts. Remember, we have, well, I'm clear on where you're at in your development. I'm pretty clear on that. But I also remember for years, people coming up here with their hands out. Lower the impact fees. Don't put a moratorium on them. Lower them, really lower them. $2,900 could have been the difference in closing costs for me to close a house. I need that $2,900. So there was people out here with their hands out. The other problem we really created in this town 7 years ago, 8 years ago, when we started approving all the developments, is we approved too many. So if we kowtow to one or do what one demands, we now cut the other one up and open us up for litigation. This will be dealt with in a closed meeting, and find out who it is we go with and how this commission decides to deal with it. But it's this development in my mind, the money over this little thing has just gotten out of control because of that developers agreement that didn't take into account many things. But I look forward to the closed meeting if we have it before the end of this term.
Yes, sir.
Mr. Mayor, may I say just for a minute, please?
Second, yes.
My name is Lee Holloway. I'm Vice President of High Springs Hills Property. Mr. Walker, I understood in the beginning of the meeting that you had made mention to the commissioner, the mayor, and the commissioners that because of the litigation with Capital City Bank, that you could have either a public or a closed-door hearing. I will say this, commissioners and mayor, okay?
There's only one commissioner sitting here today that was here 8 years ago, 10 years ago, when we were in here asking for approvals and we were doing the developer's agreement with the water sewer line. I'm hearing in this meeting tonight, okay, that people are saying things that are not correct. Mr. Walker, you're doing a great job, but you were not the city attorney at that time. The city attorney at that time can tell you exactly what was happening with the developer's agreement. Mr. Williams, it was a long time ago. You were here. You know what was going on with that agreement. We never asked for anything. At that time, we were not required. Mr. Booth is not correct. We did not have to do quarter-acre lots because of that zoning in that area out there going from commercial. We could have done 1 acre or quarter-acre lots at that time, and we could have put wells and septic tanks in because the city water and sewer was not within the distance required for us to pick it up. We voluntarily came in here, offered our own personal money, not Capital City's money, out of our pocket, to extend that water sewer line, to do the development, to bring residents, people into this community and build the community. So I'll cut it short. What I'm saying is, you close the doors and you're not talking to the proper people, and you don't have the proper people. If you do close the doors, then bring the proper people back in here that can set the facts straight. Set them straight, Mr. Booth, okay? Not opinions, what the facts were. Thank you for your time.
All right, thank you, sir. Okay, we'll figure this one out.
Mr. I have one quick question, if I may. The city manager mentioned at the beginning when he was speaking, he had spoke to the original attorney. I'd like to know who he spoke with.
Rather than give a name out, I'd like to give that to you after the meeting. I just don't like to.
Okay, I mean, I just would like to know if we're all talking about the same person of origin, or because
he was the city attorney at the time.
In 2005.
He appears on the records.
Thank you.
All right, and we can discuss this more at the closed meeting. Okay, at this time I take a motion to adjourn the special city commissioner meeting.
Motion to adjourn.
Okay, motion adjourned. I need a second to.
The biggest thing they said
What time we start?
They were given the
5-minute break.
Give us a 5-minute break, please.
to get their money. We never guaranteed.
6:40. Start back up at 6:40.
They're wanting to say, okay, at the end of the contract, we want our $700,000. Yeah. Right.
Maybe my coffee break wasn't the best introduction when we got together the first time, but I think we all have a vested interest in doing the same thing. And I don't know if Rob's, when I talked to him on the way out, he says, you guys know this guy. Maybe I'm messing this up.
No, not quite.
What he said is, part of the problem from the big problem with these agreements was this expensive sewer system that no one had any money. I was in meetings in radio.
Was it 30?
The USDA thing, packing the room full of people. That was it. And they needed connections.
You didn't put the price on. Okay, whatever they give. I think putting that $50 on there. That's skin.
And you hired the guys from Orange Park.
I think that's right.
The Orange Park guy.
Okay.
Yeah.
Yeah.